All I showed was proof that the truck was insured, registered.
All right, I'm not gonna deal with it. All right, let's set a trial date. Set a trial date.
I'm trying to get this dismissed. This is this is literally holding me back right now.
You get it dismissed on the date of trial. Date of trial.
Nice. Thanks for no, I see clear as day why I'm not getting the same courtesy. Your name is Sean Perkins? Yeah, okay.
That's the last time I checked.
Yeah. Okay, I get it.
Mr. Gubin.
I don't need to hear it. I don't need to hear the blabby blab. Just stop talking to me.
I was just going to ask, did you want to go in a breakout room?
What is a breakout room? I showed all my proof. I showed all the proof. I showed the proof, Mr. Sean Perkins. What is it? Is it my, what is it? My complexion?
Have a good day,
It's my complexion, isn't it, buddy?
Have a good day,
Mr. Uneducated Judge.
Have a good day, Mr. Gubin. You keep on talking.
How are you even a judge?
I'm gonna hold you in contempt, okay? And we're gonna give you some jail time, okay?
What a clown.
You done?
Anything else?
Are you done?
Anything else, pal?
All right. I'm gonna hold him in contempt. I'm gonna give him 30 days Wayne County Jail, all right?
Wow. The courtroom explodes in seconds. Tension hits the ceiling as the defendant snaps, accusing the judge of bias and shouting over everyone. Then comes the breaking point. It's my complexion, isn't it? From that moment, it's over. The judge stays calm, but when you call the court uneducated and won't stop talking, there's only one outcome: contempt of court. 30 days in jail. That's what happens when emotion overrules logic in front of the law.
Yes, Judge, good morning.
And who are you here on?
I am here on Joshua Gubin.
All right. He has not showed. I told him to be here in person today, and he has not showed. Neither. Oh, I think he is here. He is here. Okay, so here's the deal. It's nothing really to talk about with Mr. Gubin. I told him to come in. I gave him 30-day Wayne County Jail for contempt last year. I see him hold up a child, and his child, he didn't come down. So again, he continues to defy orders of the court, and we just don't have much to talk about.
Well, Judge, I understand that may be the court's position as it relates to this matter. May I have just 1 second? I apologize, Judge. I needed to plug my computer in. So I understand that may be the court's position. I just got retained on this matter this morning. I was not present at the hearing where you apparently held him in contempt. He obviously has an opportunity to prepare and present a defense to the allegation. I'm not sure if the court made a finding as to whether or not this was civil or criminal contempt, and further, whether the court actually determined whether it was direct or indirect contempt. Obviously, the court's ability to sanction an individual, especially with a deferred sanction.
And just like that, the courtroom flips again. Before the dust even settles from one meltdown, another case begins. Same judge, calm, composed, unshaken. This is what judicial discipline looks like. Chaos 1 minute, composure the next. Judges don't get breaks. They reset, refocus, and keep justice moving like it's just another day at work.
Well, the contempt was right on the record on the record, and I do have you can get the record for that. It was I did hold him in criminal contempt. That's why I told him 30 days Wayne County Jail. And from my understanding of the court rules, he had his opportunity to contest that. That ship has long sailed, from my understanding of the court rules, because this was done over a year ago. And the only reason that Mr. Gubin come back before me is because he got some other cases. He let the tickets go on the warrant status. He only is before me because he got the other cases. So I still need his presence here. I'm going to readjust his bond now.
Well, Your Honor.
So he continued, I've let you speak, Counselor, and I'll let you do what you need to do as far as your job, but I'm going to do my job. And Mr. Gubin continues to defy the court's orders, and we'll talk about bond right now. City of Detroit versus Joshua Gubin. Case number is SP 1411448. Count 1 and count 2. SP 1669671. Appearance for the record, please.
Yes, good morning, Camilla Barkovic, appearing on behalf of the defendant who is present.
Your Honor, Rami Hijazi, P82830 on behalf of defendant as well, Your Honor.
Okay, so you can make the record now as far as what you want to do, either counsels if you want to, as far as Mr. Gubin is concerned. Today, we'll call the date and time. There's 2 warrants out for Mr. Gubin's arrest. Let me see what the action was the last time. Mr. Hijazi was here last week when he appeared on Mr. Gubin's behalf after Mr. Gubin showed up, and I realized that he was the gentleman that was just very, very contemptuous on that day that he was here last year. The allegations were made on December the 7th, 2022. Mr. Gubin was arraigned on those matters.
Here, the judge lays it out with precision. Contempt isn't emotion, it's enforcement. It's not about ego, it's about preserving the court's authority. When he says, "That ship has long sailed," it's final. In courtroom terms, contempt is a one-way ticket. Once issued, it stands unless overturned on appeal. It's justice locking the door behind disrespect.
Go ahead and make record and speak to bond.
Thank you. Judge, I've already articulated some of this to the court off the record, but I was just retained to represent Mr. Gubin in this matter this morning. I am asking for an adjournment of today's hearing so that I may obtain a copy of the transcript of the hearing that was held where you apparently held Mr. Gubin in contempt. He does have a right to counsel in any contempt situation. In addition, he does have a due process right to obtain an accurate transcript of the hearing. I would like to obviously obtain all relevant information and then address this matter appropriately. I'm asking that you take no action today and give me the opportunity that I am requesting on behalf of my client. And if you'd like me to transition into the bond issue, I am happy to do that as well.
I'll let you go ahead with bond.
Thank you. Your Honor, it is my understanding that mere traffic matters are pending before the court, at least one civil infraction, and I believe a no insurance misdemeanor. These incidents date back to 2022 based on my review of the Register of Actions. He has appeared in connection with this matter, which the court has noted. Apparently he was here last week, and you may have recognized him. But the point of the matter is, I've known Mr. Gubin for a while. He always appears as required and as instructed. I understand that the court may have a difference of opinion as it relates to that, but I would attest to that. He is a lifelong Michigan resident. He has extremely strong family support. He is a father. He has minor children, actually one of which is visible on the Zoom as we currently sit here.
Listen to this attorney, calm, precise, unshaken. The complete opposite of chaos. This is how real advocacy sounds: facts over fury, logic over noise. He does what true counsel should, defends rights, upholds due process, and proves that even in contempt, fairness still matters.
Upon conviction, of the only misdemeanor with which he presently stands charged. His maximum sentencing exposure is minimal. He is obviously presumed innocent at this point in time. And for all of those reasons, Judge, in addition to other reasons, such as his lack of any significant or substantial criminal history, which is a factor that the court shall consider when it sets bond, I believe a personal is warranted. And retaliation for...
This part hits hard. The attorney paints a human picture, a father, a business owner, a lifelong resident. It's a powerful reminder, defendants aren't just case numbers, they're people. The defense is working to shift the lens, from rule breaker to a man with roots, responsibility, and a life beyond the courtroom.
Very well, bond is going to be set at $2,500 cash. I still, the order of Mr. Gubin still showing up because despite what you've articulated on the record, Ms. Bachowicz, we put the warrant out for Mr. Gubin's arrest a long time ago. He was supposed to be in person here today. He's not. He also has an assault and battery case that he has a warrant out for his arrest for as well. So he showed the court and demonstrated to the court that he has, not only with this court, but with the other courts and other judges in this courthouse, that he has a failure to appear or something. So bond is $2,500 cash, and it's still ordered that Mr. Gubin show up in person to the court for the conviction hearing, and we will address, and you can appeal the matter to a higher authority if that's what your client chooses to do.
So, Your Honor, I have a comment as it relates to a cash bond. I'm asking that the court impose a cash or surety bond. My interpretation of the court rules as it relates to bond and statutory authority allow the defendant to elect whether he posts a surety or posts a cash bond. And my position is the court cannot outright prohibit a surety. So I'd ask for the addition of a surety provision.
The court has made its ruling, Counselor. You can take it to a higher authority.
Thank you.
And finally, the gavel drops. $2,500 cash bond, no leniency, no second chances. The judge stands firm, unmoved. This is courtroom reality. Mercy has limits. After defiance and no-shows, patience turns to principle. It's not about power. It's about preserving respect for the law. One outburst led straight to jail. Another calm defense still met the same fate. Two cases, one courtroom, one message, the law always wins.